Go!
Breaking news. Welcome to today's headlines. Hill Health called to rule on Nnamdi Kanu's request for DSSDG to give oral evidence. Hill Health called to rule on Nnamdi Kanu's request for DSSDG to give oral evidence. To my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. A federal high court, Abuja, on Monday, fixed March 16 to rule in a motion filed by the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, for the Director General of the Department of State Services, DSS, to give oral evidence on a state of health. Justice Taiwo fixed the date after counsel for Kanu, Maxwell Okpara, and his lawyer to the DSS, Idowu Awo, presented their arguments for and against the motion on notice. The news agency of Nigeria report that Kanu, through his lawyer, Okpara, had in a fundamental right enforcement suit marked FHC ABJ CS 1585-2021 sued the DG of DSS and the office as first and second respondent, respectively. He also joined the Attorney General of the Federation, AGF, as third respondent in the suit dated and filed December 13, 2021. Okpara had alleged that the health of his client was deteriorating in the DSS custody, among others. At the resumed hearing, Okpara filed a motion on notice dated February 14 and brought pursuant to Section 116 of the Evidence Act. He argued that there were conflicts in the counter affidavit filed by the DSS and that only oral evidence of the DG and Kanu could clarify the issue. We want to call Kanu and Director General of DSS to testify, he said. The lawyer said other relevant processes had been filed to raise one question: whether the court could transfer the matter to a general cost list to enable it to hear the matter. He informed that though the first, second, and third defendant had filed their counter affidavit, he had filed a reply on point of law. We urge, my lord, to allow the parties to call oral evidence in this matter because the applicant complained that a quack doctor from DSS has taken his blood sample about 20 times without bringing forth any medical report, he said. He urged the court to grant the application. He argued that while the judge had powers to call oral evidence of parties, Kanu's lawyer had not shown how the doctors attending to his clients were doing quack work. He further argued that merely stating that the medical doctors his office assigned to attend to Kanu were quacks did not amount to conflict. It is important to note that the applicant has not denied the above assertion by the respondent, neither has he shown by material particulars that the listed medical practitioners are quacks. The onus lies on the applicant via a further affidavit, he said. He prayed the court to discontinue the application. We humbly urge that the application be thrown away and let us go into the substance of the case, he said. In the counter affidavit dated February 24, Awo argued that it was common knowledge that Kanu was currently standing trial on a 15-count charge bordering on terrorism before a sister court. He also argued that it was common knowledge that Kanu was earlier granted bail by the trial court presided over by Binta Lunyako, but he jumped bail. He said he was rearrested and rearraigned before the judge. Awo said that there was no court order in existence anywhere, which is to the effect that applicant Kanu should have unrestricted access to his personal physician while in the facility of the first and second respondent. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let us know what your view